we thought about a dynamic that would emphasize the presence of our foreign professors. So we thought about here first Professor Sandefur, after that Professor Alessandra De Luca, so that we can get in touch with their researchers. And after that, we, the Brazilian professors, we can debate and talk about what was said, what was exposed before. So I open the microphone to Professor Sandefur so that she can talk to us. Thank you, Professor.
Thank you very much. Good morning, everyone. It's a pleasure to be with you today and really an extraordinary privilege. Uh-oh, we're doing something.
Yeah, I'm trying to move the video so that you can
okay.
see. I'm sorry. Yeah. You can start. I'm sorry.
Oh, no worries. So good morning, everyone. It's extraordinary what we can do now with technology. I'm very sorry not to be with you in person, but it's wonderful that we can all kind of be in the same place, sort of, by being able to see and hear each other. That's really fantastic. So it's a privilege to get to talk with you about this. What I'm going to talk about is comes out of the United States, but I do think it's really something that's happening around the world, which are some new activities in access to justice and some new ways of thinking about access to justice. And the title of my remarks is Civil Justice at the Crossroads. And the reason that I've given my remarks that title is that I think we really are at an exciting but also important and challenging moment of choice, where we can go on trying to promote access to justice the way we have for the last 50 or 100 years. And I think if we do that, we'll achieve the same results we have over the past 50 to 100 years, which is it's an intractable problem. But I think that there's a growing evidence base that allows us to think about these issues in a different way. And that different way of thinking permits kinds of action that I think could help all of us around the world take some action on what's now a tremendously restricted and unequal situation for access to justice in most countries around the world. So I'm just going to review some research about how people think about and understand their justice problems, and then also about what we know about services that don't involve traditional attorneys that can assist them. And I think both of those bodies of evidence give us some really exciting new opportunities. So thinking about how ordinary people think about their justice problems and what they do about them, we've been studying this for about 60 years, and there's research in lots of different kinds of countries around the world. So countries like Canada, the United States, or countries like Kenya or Mali, the United Arab Emirates, like all kinds of, they're very, very different in their political structures. They're very, very different in their legal systems. But you see some really striking findings when you look across these, what seem like very different contexts. So the first thing is that if you want to understand how regular people, ordinary people think about their justice problems, you can't ask them about their experiences with law or with justice because they don't usually understand their justice problems as legal. So everywhere that we've looked at this, most people just experience their justice problems as problems that emerge in some kind of relationship. So for example, if the issue is that the wage and hour laws in your jurisdiction say that if you work over a certain number of hours, you should be paid what in the United States we would call overtime, so a premium wage for those extra hours. If you're not being paid that premium wage by your employer, even though it's a law that says that you should be, you'll usually understand that as your employer being a bad person or being careless or trying to cheat you. But you won't really think about it as a violation of some federal regulation or a local wage ordinance. So if you want to understand people's experiences, you have to ask them about those kinds of concrete problems. So are you 2 or 3 months behind on your rent? Does your employer owe you wages that he or she's not paying? Something like that. And if you do that, what you find is that there's an enormous amount of this activity in every society that folks have studied. So in the United States, you have fully 2/3 of adults in a representative sample of residents of a Midwestern city, so kind of an ordinary middle-sized city. 2/3 of adults have at least one justice problem in any given 18 months, any given year and a half. That's a pretty common rate. The rates we see across countries range from the lowest you would see is 1/3, and the highest you would see is around 80 or 90%, depending on the country that you're in. So these problems are very, very common, and all groups in the studied societies have them. So majority racial and ethnic groups have them, as do minority racial and ethnic groups. Different kinds of religious minorities have them, as do people who are not religious minorities. Men and women have them. Poor people have them. Rich people have them. They affect all groups in society, but they're not equally distributed. So, for example, in the United States, race is a big division in our society. It organizes lots of things. So even though every group, whites, African Americans, blacks, Hispanic, Latino folks, have justice problems, in this particular city, blacks and Hispanics were more likely to report justice problems than white people. And similarly, poor people are more likely to report justice problems than people who are not poor. So it's very widely spread activity, but it doesn't fall equally on the different groups in society. Around the world, what these studies show us is that civil justice problems affect core areas of life in every country that we've studied. So a lot of them involve different kinds of things related to being a consumer, so buying and selling the stuff you need to just have a daily life, whether that's your cell phone or repairs to your house or repairs to your car or insurance, all kinds of things like that. Lots of people have problems affecting livelihood. So in the United States, in a country like the United States, that's your job usually. Most people are employed in the formal economy, so it's some kind of formal wage or salary. In other countries, that livelihood might be in the informal economy. It might be from farming, but livelihood becomes a big issue. Land and shelter are important and common areas with civil justice problems around the world. Money and debt. And then, because in most societies at this point in history, we've decided for whatever reason that lots and lots of stuff around family relationships should be able to be resolved only through law. So, for example, in the United States, if you want to get divorced, you can't just say, I'm out. You have to go through a court process. So lots and lots of stuff related to family and dependence are justice problems that affect people around the world. So you have all this activity. It affects core areas of life. It affects every group in society, but it doesn't affect them all equally. The other thing you see around the world is that so there's a tremendous amount of activity. In the United States, we have, I think, 327 million people. This level of activity is 100 to 150 million justice problems every year. So that's a lot of civil justice activity. But most of it in the United States and everywhere else does not make it to the formal justice system. So if you think about the formal justice system as courts and then administrative regulators, tribunals, if you have those in your jurisdiction, and then whatever kinds of attorneys you have, so notaries, barristers, solicitors, civil law attorneys, whatever it is, a minority of this activity ever makes it to those kinds of justice professionals. In the United States, it's somewhere between 14 and 24%. In other countries, it might be 11%. Just most of this activity is handled in some other way. And one reason that we see that people don't take their justice problems to attorneys or to courts or to regulators or to civil authorities of different kinds is that they don't understand them as legal. And it turns out that the way you think about your problem plays a powerful role in shaping the solutions that make sense to you. So in this study of a community in the United States, one of the things we did is if someone said, my employer's not paying me overtime, or I'm having a fight with my ex-husband about which holiday I'm going to have the kids for and which holiday he's going to have the kids for, the different kinds of problems that people experience that are justiciable, even though they may not know that they're justiciable. We said, okay, you've told me you have this specific problem. What kind of problem is it? Is it a moral problem? Is it a personal problem? Is it a bureaucratic problem? Is it a private problem or a community problem? Is it a legal problem? Is it just bad luck? In the United States, people are very religious, and so another option that we gave them was, is this part of God's plan for you? So if you say, okay, you've told me you had this specific problem, what kind of problem is it? The most common way in which Americans will describe this is 60% of problems, is it either bad luck or part of God's plan? This is something that either is just happening to me because that's just the way the world is, or it's happening to me because there's a controlling intelligence that's given it to me as a life experience. If this is just bad luck or if it's God's will for me, I'm probably not going to file a lawsuit about it. That's a frame that will lead me to doing nothing or to lumping it, to use a classic expression from the disputing pyramid research. So that's the most common way in which people will describe their problems in the U.S. as bad luck or part of some plan for their lives. There's another about quarter of problems that they describe in ways that suggests they don't think outsiders should be involved. So they'll say this is a private problem, or it's a family problem, or it's a community problem. So maybe there are people who should be involved in working on it, but it's not the formal justice system or a service provider that I don't know well or something like that. It's only 10% of problems in this survey. And again, these are all problems selected because they are civil justice problems, because people can take action on them using laws and rights. For only 10% of those problems did people think that they were illegal. So it's just a very unusual way of thinking about all of this activity that happens in our lives that has civil legal aspects. We just don't think about it that way. The other thing we see, so if you've got all this activity, everybody has it, it's unequally distributed, people don't think it's legal, then you can look and see, well, okay, so how do they handle these problems? Well, of course, they don't take them to law very often because they don't see them as problems law can solve. Most often, they either do nothing, so that's 16% of problems in this city-based survey, or they try to resolve the problem on their own. That's about 46% of problems. So the most common thing to do is to try to handle this yourself. If people seek some kind of help, the first place they go is their immediate social network. So to their family or friends, they ask them what those folks think that they should do. The last place they go is outside that immediate social network to some kind of service provider who may or may not be a lawyer. So in this particular survey, it's about 21% of problems that make it outside either your own life or your life with your immediate intimates to a city agency or a membership organization that you're in, or an elected official or the police or a lawyer or the courts. So most of this stuff is handled informally, and this is true in most countries, informally within whatever relationships you already have. So one of the things we asked in this particular city study was, okay, well, why didn't you seek help outside your friends and family? Because in the United States, one of the big arguments is the reason, the cause of a lack of access to justice is that lawyers are very expensive. And American lawyers are very expensive. So I think on average, they charge about $200 an hour. So if you think about an ordinary justice problem, that's very quickly several thousand US dollars, which is a lot of money for many people. But if you say to people, why don't you seek help? Cost explains why they didn't seek help for about 18% of problems. Not knowing what to do is about 10% of problems. Thinking that doing something would be too stressful is about 8% of problems. But the most common reasons people give for not looking for help with their justice problems reflect a sense that they understand what's going on. So the most common response is, I don't need any advice. I already understand the situation. I know what I can do. And I'm doing it or not doing it based on my knowledge and my ability to make judgments about this. I don't need anybody's help. That's about 45% of justice problems that don't receive help. The reason is the person believes I don't need any help. The second most common reason is getting help wouldn't make any difference. So that's about a quarter of problems. And the interesting thing is that sometimes people are totally right, right? I mean, sometimes people correctly recognize that there isn't anything that you can do about this situation, that you'll lose, or it'll just be costly and time consuming. It will mess up a bunch of relationships that are important to you. So why bother? And people are sometimes right that they don't need advice. They certainly very often understand their situations. I think for access to justice, our question, sort of the place where we need to act is people who don't recognize perhaps that they do need help, and that help could make a difference. And part of that help making a difference issue is they may not be aware of their rights. They may not be aware that they have possibilities for action. But another part of it is that particularly with poor people, if you're looking in the United States, folks are pretty efficacious. They try to solve the problems in their lives in the ways that make sense to them. And if you try several times and it doesn't work, you may learn that trying to solve your problem with your landlord or your problem with your employer is just not going to be successful. So why not do it? And so it's partly an educational issue. Like, how do people think about what's actionable and what's not? But it's also partly an institutional issue. So if you set up institutions that make it really difficult or discouraging to take action, people are pretty smart and they'll learn not to take action. So those are the basic things that we know about public experience with justice problems. The problems are everywhere, but they're not equally distributed. They involve basic needs and core areas of contemporary life. People don't usually think of them as legal problems, and they don't usually turn to lawyers or courts to try to handle them. And that's true in the United States and everywhere else that this issue has been studied in this way. Now, at the same time that there's been this explosion of these surveys, and if you're interested in learning more about them, Pascoe Pleasance at University College London has put together a really nice review paper summarizing everything that we know from this 25 or 30 years of work. In addition to all that activity that's about kind of the demand side for civil justice, you could think about it that way, there's a lot of new activity about the supply side, about the different ways that we could provide services to ordinary people who have civil justice problems. Some of you may be familiar with Namati. So Namati is a big network of paralegal, they call them barefoot paralegals, but of different kinds of service providers that are usually recruited from the local community to provide assistance in a limited way with one kind of problem, like to help you establish land title to the small patch of land where you farm, so that, for example, when you die, your kids can get access to that land, right? So very, very straightforward legal processes that involve these basic issues being assisted by all different kinds of non-fully qualified attorneys all around the world. So there's a lot of this activity, and there's activity in the United States as well. Now, what these non-lawyers, I'm going to call them that, can do depends a lot on the regulatory framework in which these things emerge. So to give you an example, in the United Kingdom, lawyers they control parts of the practice of law, but they don't control the delivery of legal advice. So in the United Kingdom, lots of people who are not legally trained can give legal advice and they can charge for it. And so that means you can create a non-lawyer role that can tell somebody what to do in their specific circumstances, given the law and the facts of their specific case. And that's perfectly okay in the regulatory system in the UK. In the United States, that's almost never okay. So in the U.S., we have one legal profession, for the most part, attorneys. It's regulated at the level of our states. And in every one of those states, lawyers have a complete monopoly on every bit of the practice of law, including the provision of legal advice. So if people who are not lawyers are behaving the way they're supposed to under the rules, they're never giving people specific guidance about what to do in their specific situations. So the capacity of these roles to act is shaped a lot by those kind of forms of regulation. But even in the United States, you can see that different jurisdictions are creating very interesting and seemingly extremely effective non-lawyer roles, even when their powers are restricted in these ways. And probably the best example in the United States is a program that comes out of New York City called Court Navigators. So in big cities in the United States, you have these very, very high volume courts that process lots and lots and lots of one kind of case. So eviction courts, so people who are being sued for not paying rent by their landlords. We have another gigantic volume of debt collection cases, and this is typically consumer debt, often credit cards, so it's unsecured, there's no collateral. So the only way that the creditor can get money from you is by suing you if you don't just pay them. And so you'll have courts where 59,000 such cases will go through the court in a given year in a single courthouse. And in cases like evictions and debt collection, and also family cases where we have an enormously high volume, you'll very often have at least one party who has no attorney. So in the eviction courts in New York City, when we were doing our research, it was about 97% of tenants had no attorney, and about 97% of landlords had an attorney. So you have this enormous imbalance. If you look in debt, you see a similar thing. So in the United States, we have a third-party debt buying industry. So after your credit card tries to get the money from you, it gives up after a certain time, and it sells your debt to a third-party service that then makes a bet that it can collect enough money from you to make some profit on what it paid to buy your debt. So those companies all have lawyers, and they file thousands and thousands and thousands of lawsuits every year. And then a few people will come in, almost always without attorneys on their side, and confront these debt buyers' lawyers. So courts in the United States hate people who don't have attorneys. And part of the reason is that they get confused and they take up a lot of court staff time. They ask too many questions, they get lost, they don't understand how to express themselves in the ways courts understand. So it's partly a self-interested dislike of these litigants. But courts also worry about fairness. So if the law and the court process is so complex that somebody who's trying to handle their own case can't understand what to do, they're confronting almost always someone on the other side who has an attorney, so there's this imbalance. Courts have tried to figure out ways to solve that problem without giving everyone attorneys, because that's just not going to happen. So they've created their different jurisdictions have created these different kinds of roles where people who are not lawyers help you with your legal problem. And one of the most interesting examples comes from New York City with this program called Court Navigators. And the most effective kind of court navigator is actually a social worker. So these are folks who are assisting unrepresented litigants who are being sued for unpaid rent and therefore are at risk of eviction. And their clients are the same clients that legal aid lawyers in the U.S. work with. So they're very low income. In New York City has an enormous number of people from all around the world. So even though the language of the courts is English, there are many people who are in the courts who don't speak English well enough to participate. So these are low income folks, many of whom have language limitations with respect to the language of the court. They may have disabilities of different kinds, physical disabilities, cognitive disabilities, and they also have significant rent arrears. So in New York City, I think the average case taken by the Navigators had back rent of at least $4,000, which again, if you're poor, is a lot of money. So the ratio between the rent you owe and your actual income is quite high. So navigators, who are not attorneys, are permitted to accompany these litigants throughout every piece of the court process. So they can go with them to talk to the court clerk. They can go with them to talk to the lawyer on the other side, the landlord's attorney. And they can appear with them when that tenant appears in front of a judge. And they can answer factual questions addressed by the judge. So they can't give legal advice and they can't represent, but they can accompany and they can inform. And the logic of this was that when people are involved in these court processes, they get very confused and they get stressed out and they feel very anxious. And so they can't answer questions well, factual questions like, here's the receipt for my rent. And so the navigator is supposed to be able to help them do that. The other thing that navigators do is work with people outside of courts to assist them in connecting to services that will help them pay their rent. So that could be different kinds of public benefits that they're eligible for, but they aren't getting right now. So they could be veterans benefits or social welfare payments or disability payments. They may connect them to financial education so that they understand how to manage what money they have in a way that makes it easier for them to pay their rent. One thing that you see around the world in low-income households is you often have multi-generational households, because that's the only way you can afford to have a house is to bring everybody together. And so one of the issues that emerged in New York City is sometimes you'll have an elderly person with an adult child living with them, for example, and then the adult child's children, and the adult child will be working but not contributing to the rent. So sometimes these social workers will bring in family counselors to sort of get everyone on the same page about how everyone needs to contribute their resources to solving the problem of the rent. So following you around in court, but also helping you with all this stuff outside of court. So at a pilot scale, so not an enormous number of cases, in their first year, the success rate for this program was 100%. Now, it wouldn't stay 100% if it went to scale, right? If it were serving 39,000 people a year instead of 200 people a year, it would not do as well. But that they were able to prevent eviction for everyone they served is pretty remarkable, even at a pilot scale. And their cost is about half of the cost of a legal aid lawyer. So in terms of just paying for the service. So it's a much cheaper model that appears to achieve the goal you want pretty well. There are lots and lots of experiments with this kind of thing in the United States and around the world. And I think this is a really exciting opportunity if we want to expand access to justice. There's just one final point from research that I want to make. And that is that one of the things that makes lawyers so important is that courts can't behave without them. And so if what lawyers are doing is helping courts do what they're supposed to do anyway, maybe we should find another way to help courts do what they're supposed to do anyway. And I'll give you an example from the United States. So I did what's called a meta-analysis, which is a study of studies, of different studies of how lawyers changed case outcomes in ordinary litigation. So evictions, debt collection, unemployment benefits claims, state tax disputes, etc. And so one of the things you see is that the way lawyers make a difference in those kinds of courts in the United States is not so much by understanding the substantive law, because there's usually not a lot of exciting constitutional rights at stake, but understanding kind of basic procedures. And so one thing we can ask ourselves is, do those basic procedures need to be as complicated as they are, or could we achieve the same justice goals with having simpler procedures, in which case having a lawyer wouldn't make as much of a difference? But the other thing you see in the United States, and I suspect this is true everywhere because it's about human nature, is if you're in a court where lots and lots of people routinely appear unrepresented, and you do a very high volume. So in American eviction courts, you might do 60 cases a day, 100 cases a day. And you can do that because lots of people default. They don't show up for their case. But you can also do it because for people who do show up, there are courts that process cases for 2 minutes. You have 2 minutes in front of that judge, and they move on to the next thing. And of course, they're doing that because they think, wow, I've got 100 cases to get through. We need to be really efficient. What happens in those contexts is that courts start to kind of take shortcuts around people's rights. Like they don't require the other side to provide evidence of its claim, or they don't swear in witnesses when there's actual testimony, or they don't allow the tenant or the debtor to present evidence for their side, or they don't apply the rules of evidence, whatever those might be. And so when a lawyer comes in there, the court remembers that it's a court and starts to act like a court, which is good, right? It's good that they sort of can bring themselves back into line. But it's kind of strange to me anyways, to think that the way we would make courts follow their own rules is by requiring a lot of individuals to get attorneys to come in and make courts behave. I mean, maybe there are opportunities for systemic reforms that would level the playing field without providing every individual to get an attorney. I just want to make one last point about this. I mean, there's clearly a lot of opportunity here, and I think it comes from this new evidence base, understanding what work has to happen for just and accurate outcomes to occur, and understanding how people think about and understand their justice problems. But in order to use this knowledge, we need a little bit more knowledge, I think. So we know that some people can understand and handle their justice problems without legal assistance, but we're not very good at figuring out who those people are, and designing interventions that get them at a moment when it would be really effective for them to get some help. So we need to understand that better. Who can handle this stuff on their own and who really needs assistance? We're not very good at understanding the flip side of that, which is which kinds of legal problems really need lawyers, because there certainly are some. There are legal matters where the issues are complex, where the procedures are complex, and we wouldn't want to simplify either of those things because we need the complex law to achieve some other goal. We're not very good at recognizing when you need a lawyer to help you with that problem versus some kind of non-lawyer person like a navigator. So we need a lot more evidence to figure that out. And we're also, and I don't think this is an evidence problem, maybe it is partly, we're not very good at recognizing when sometimes the problem is owned by the justice system. So that example of the lawless lower courts, that's not really my problem, right? I mean, that's an organization that has rules and resources that it should be following and it just isn't. So, you know, there's a whole set of issues like that that are really system problems and they involve system reform. And so identifying those kinds of problems is a partly evidentiary issue and a partly political issue. But I think all of these things are resolvable. And this is a really exciting time, as we're going to hear from other research and other perspectives on this panel, where people are re-engaging with access to justice in ways that are new and creative. And so I think this is a really great moment of opportunity, and I look forward to hearing from everyone else this morning. Thank you.
Thank you, Professor Sandefur. I think that we have a lot to think and a lot to debate after your presentation. We have a situation in Brazil with a lot of lawyers, so I think we can dialogue with your presentation. But first, I will call Professor Alessandra De Luca so that she can talk to us. Can you please?
You have to put here. Use this because otherwise I'm afraid she will lose. Yeah. So yeah, I would prefer probably. I think. Okay. For me, it's okay. So. No. For me, it's. Professor De Luca. Hi. Can you see me? Yeah. Okay. Good morning.
Good morning.
Good morning. And can you hear me? Yes. Okay. So, first of all, thank you. It's really a great privilege and an honor for me to be here today. And first of all, I need to spend 1-2 minutes to, no? I have to put it, oh, sorry. May I? I prefer probably, yes, it's better. To thank you, the organizer of this conference, first of all. It's the first time I visit this country, so this conference is for me, first of all, an opportunity of personal growth. I mean, knowing people, getting to know a different context. And I must add one thing. I know that the title, the subject of this panel today was chosen also because to mark somehow the fourth anniversary of the publication of Access to Justice, the general report. And as Cappelletti started his work in Florence, I feel somehow a kind of hair. And so it's really a singular privilege to be here so far from home, from his home, and be here somehow to honor him. Because we all in Florence, we do feel his heritage, and we really appreciate being able to discuss his ideas today somehow. And I had prepared some slides, but of course we will do without that. I hope I will be comprehensible anyway. The topic for my presentation is access to justice in the EU. I choose the EU perspective, European Union, because I mean I saw there was the only European. I thought that some interesting things could be said. I choose the European Union level, well, because I think it may help us see some trends, some general features and some trends. We can't speak separately of all European countries. I may make some individual references when needed, of course, but I mean, it was a kind of perspective that could be useful to introduce some interesting ideas and trends. And that's why EU will be my level. Of course, predictably, my starting point will be Cappelletti's three waves. I've chosen to follow his famous three waves perspective to try to sketch this picture. Of course, I will be synthetic on some points, so that if there is a debate, we can discuss some of them, of course. So, Cappelletti's three waves, I think that, I mean, they're still useful. The first thing I did as I was looking at the old book, take it from the phone and reading it through. So legal aid, the representation of diffuse interest and access to justice approach. Legal aid, well, I mean, as a lawyer, the starting point is there any textual reference, any legal provision? And yes, there is. At the EU level, at the constitutional EU level, we have a provision. I just quote just two lines. Article 47, paragraph 3 of the Charter of Fundamental Rights of the European Union, legal aid shall be made available to those who lack sufficient resources insofar as such aid is necessary to ensure effective access to justice. So the right is there, written black letters. And it is constitutional level. Nowadays, it is the primary source at the EU level. But these provisions are very recent. They came, I mean, the Charter was issued in 2000, but it is in force as a legal instrument since 2009. So the question is, what was the situation before? The answer was that at the other EU level, Council of Europe, we had, since 1950, so just after the Second World War, the European Convention on Human Rights, whose Article 6 is devoted to right to fair trial, and there we found some textual provisions. But Article 6 explicitly provided for legal aid as a right only for criminal cases. For civil cases, there were some rights, but no specific explicit provisions. What happened is that the European Court of Human Rights actually read in this Article 6 also this right to legal aid in civil cases. First of all, in 1975, it established that a right of access to justice existed, that it was inherent in the provisions concerning fair trial. First of all, you need to have access. Then we can discuss how fair the trial is. That's the first issue. And it was a case against the UK. It was a case of a prisoner who was denied access to a lawyer. He thought he needed a lawyer because he has seen that there was a legal problem in his situation, but the authority thought that his position was meritless, so he was not allowed to even to speak, to have a lawyer's advice. First thing, it is inherent in this provision the right of access to justice in any kind of court, civil, criminal. Then the specific problem, legal aid for civil cases. A few years later, 79, against the UK, Airy v. Ireland, so in UK, I mean the English system. It was a family case, typical, a divorce. Again, a very typical court situation. The answer of the court was again, yes, there may be situations when legal aid, even in civil cases, is a right of the person. And why? One, representation is compulsory, because in civil law systems, and in that case, for divorce case, we have this problem. We don't have the possibility of people representing themselves. Litigating persons are just limited for very few cases. So, first of all, if it is compulsory and people can't pay, someone else has to give this service. The second issue, if the question is too complex, This means even if it is not compulsory because the law established that, but if the situation, the legal situation is too complex, then people have the right to have access to justice paid. By whom? That's the problem. Then there's a lot of cases going on, and I don't want to discuss. They are going all around this issue. Is there the right, an infringement of the right to legal aid in that specific case? The point is that the court has been cautious because they were aware of the effects of decisions establishing a wide-ranging legal aid. And therefore, when they thought that there was an infringement, it was always in situations where, or very specific situations. So the decision was always narrowly based on the specific circumstances of the case and connected to the need of the effectiveness of access to justice. Has an effective access to justice been guaranteed or not? So what has changed when the new provision, the charter, entered into force? Well, the recognition, the official recognition of all these kind of, all the development of the case law of the Court of Human Rights was somehow, put into black letter. So all these developments were recognized, they were recognized at a constitutional level. So this is already something important, even if the right was already there. Then, secondary instruments. So what's the situation at the EU level? We have a directive on this issue on legal aid. Directive means, you all know, but just to be sure, that if there are students, this is an instrument binding for the states, for all EU member states, but binding only insofar as the result to be achieved. But the means, the tools, the measures to be adopted in order to achieve the results are something that the states can choose. So it is binding, but up to a certain point. Then there's a minimum level of harmonization because we all have the same result, but the ways through which we get to this result may be different. This directive, and then I quote just from the title, was adopted to improve access to justice again in cross-border disputes by establishing minimum common rules relating to legal aid. So it was limited to cross-border disputes because civil matters are something for the states to regulate. Only, cooperation between states can be an area where EU competence exists. But this directive is important because it establishes the minimum common rules. So we can see the basic elements common to all the system. And what these basic elements are. We all have a judiciary system, what Capelletti level judiciary system. So the idea is, first of all, lawyers are going to be paid, but they are going to be paid by the state. The second issue is people have a right to legal aid, provided that they fulfill the conditions established by the law. So it is a right. If you fulfill the conditions, you are eligible to, and you have a right. That's overall the idea. Then there's the problem which is the scope of legal aid. And here, so assistance, pre-litigation assistance, these basic things. Conditions usually refers to economic situation of the parties. So states may put thresholds, economic thresholds, and they tend to be very low. I must add this. And then merit conditions concerning the merit. And here the threshold is not so low. It is only a non-manifestly unfounded limit. So you don't, only if your case is not manifestly unfounded, you can be refused legal aid. So the financial conditions can be, scrutinized. But as far as the merits, the only institution who has to decide about the merits is the court. The point is this directive effective? Then what has happened in practice? All states had to implement in their system. They all did it. Very often they simply extended the existing regulations to cross-border disputes. That was the easiest solution. But the point is, how many cases do we found? Is it used or not? The answer is, on the basis of the few researches we've seen, it is not so used. And the answer is, why? The question then is why? And the answer cannot be simply because the directive refers to just cross-border disputes, because there are cross-border disputes. The problem is a more general problem, is legal aid itself. I mean, all over the world, in Europe, I think in other systems, there have been reforms in this area, and all these reforms tends to reduce legal aid, lower the financial thresholds, or not, adjusting to inflation. That's just a simple way not to do things. It's just a way to reduce the access, or excluding some kind of disputes, for example, again. And this is a general trend. Wherever you go, you see this trend, especially for civil legal aid. They tend to be somehow to keep some criminal legal aid, and even if they reduce the threshold. But for civil, I mean, the Cinderella legal aid. That's the general approach. And in England, which was the cradle probably of the judiciary model, with the 2012 statute, they almost abolished it. It is no more a right, and for most cases you can't use it. You can't have access to all services, but just to the local services. So it is, it is disappearing somehow. But Cappelletti himself saw this. I mean, he, again, a quotation, the establishment of legal aid requires funding, which is the basic problem with legal aid schemes. It was a basic problem even at that time. Nowadays, it is even a greater problem. So the question is open, how to find ways to fund somehow, alternative ways of funding. Because the problem is there, is still there, is even worse than it was somehow. But alternative ways must be found. And I don't have answers. We heard something very interesting from Professor Sandefur this morning. Other answers, as creative answers, are needed. Second wave, representation of diffuse interest. This is a very important issue at the EU level, especially in two areas of law, very typical areas where diffuse interest exists. Consumer law, which is one of the main concerns. If you want to build an internal market, you need to protect consumers. So there's a lot of legislation enhancing consumer rights, but then there's the problem of effectiveness. They have all these rights, but how can they actually implement them? And then the other area is antitrust law. Another area, so for the internal market, we need strong measures against anti-competitive behaviors. But then, again, how to be sure that all these very nice things are effective. The problem with these cases, of course, is that very often they are too small. And any sensible person would think, even if they recognize they have a right, it has been infringed. You don't start a claim for very low amounts. It's irrational. On the other side, the aggregate damage they produce is enormous sometimes. And the unlawful advantages that some businesses derive from this are really unacceptable, so politically, socially unacceptable. So the question is there. And Cappelletti highlighted several different approaches to this problem. One was the typical governmental approach, so public regulation as a solution. Then the private attorney, a more sophisticated way of private attorneys. His final conclusion was a mix of private and public is the best option. But what is the situation in Europe? Traditionally, our answer has been public, public, public. Because, private enforcement has one aim, compensation, full compensation. We agree with this, but just compensation. Punish and deterrence are public functions. Whether you perform them through criminal law, through administrative law, but you can't perform them through private enforcement. This was the basic approach. And very, strong, some culturally rooted approach. Yet the state is there for that function, not the parties. But then, the story of representation of diffuse interest at the EU level is a story of recognition that there's a problem with what we can label like the governmental approach. It is not effective. There is under-enforcement, under-deterrence. That's the point. We all agree on this. So the next question is how to solve this problem. The answer would be introduce some kind of private enforcement, the natural answer. But then this creates very strong reactions. The idea of the American class action is there in the debate. It is a kind of, a threat, something everyone looks at with suspicion. From a political perspective, from the legal procedure perspective, finality of decisions, res judicata, all the basic principles of our civil procedure are undermined by this strange animal. Then we have businesses who don't like class actions, of course, because it is effective. And because that's true, they are trying to limit in the United States, but through arbitration, all this stuff, but it is effective, so it is a threat for them. It is a threat for our theories, for our fantastic dogmatic theories, and so that's a problem. The problem is how to find a European way to deal with this issue without importing the US class action. That's the big problem. And see, the mistrust towards the European class action is so deep that you find it also at the linguistic level. In official documents at the EU level, we call the whole issue collective redress. We don't use representative actions, no translation, no presence of the expression class action. Group action, whatever you want, but no class action. It is something we must, a kind of phantom, I don't know, something we really fear. We don't want it, and not even to call it. And Italy is an exception from this perspective. We have an azione di classe, which is the perfect translation, understandable, and it was introduced after the Parmalat scandal, probably you may recall it, so a situation, and it was entered into force in 2010. We used the, provincially, we decided to use the American translation, but what we introduced was not a class action. We just had the opt-in system. And this means that no class action. And the first cases were, a failure. 3 people being restored, 10 people. So, nothing to do with it. So we have the name, but we don't have a class action. That's the situation. And all over Europe, just collective redress. The catchword is that never mention class action. We want something, but not that thing. And especially we don't want opt-out. That's the basic thing. We don't want it. It is inconceivable. And from this perspective, the Brazilian experience is very interesting for us. There's a significant amount of literature in Italian about the Brazilian class action, because when the discussion about the introduction of class action in Italy started, there were conferences and books. So it is something we can learn from Brazil, probably. We as European, not just as Italian. Then, if this is the scenario, what's the story of this journey, the main steps, very briefly? Starting point probably is a green paper, 2002 green paper, so a policy document. The European Commission on antitrust damages think, okay, we must do something. A document exploring possibilities, and one of them was something like group action, and even the possibility of some kind of punitive damages was there as a possible option. So something, okay, so you may think, okay, we are going in that direction. The reaction were so strong that everything had to change. The directorate, the competition members of the commission were strongly in favor of a class action, of a typical US class action. But probably, they were not critical in their approach. They were not aware that that solution was not feasible. And the reactions were very strong also by very strong states. France, Germany strongly oppose. And if they both oppose it, you can't have it. The subsequent policy document was a kind of retreat. The white paper said, no, we can't. And the words are very, compensation has just the function, damages are just the function of compensate, and we must find a distinctive European solution, all this stuff. Then the new head of the commission was, the Barroso, who was president of the European Commission, was expiring his term. Then he was re-elected, but the political bargaining, among the elements of the political bargaining, there was no class action, and please, whatever you want, but no opt-out. Never. And the result was that the Commission worked a lot of documents, a lot of paper, no results. The final results, 2013, are simply a recommendation. So not a binding tool, very general for all EU things, but I mean, nothing really interesting. And there was the proposal for a directive only for antitrust law, but that directive did not mention, did not contain, does not regulate, because actually in the end it entered into force, collective redress. So we have a EU directive on damages deriving from antitrust, but no single word on collective redress. So, I mean, the scenario is so dark? No, it is not so dark. There must be hope. There is hope. First of all, at national level, when the EU level stops, sometimes national levels may help. You can not go lower than the minimum threshold, but you can go up further. So there are national legislation providing some kind of class actions, not really effective, but I mean, there are some tools providing opt-out class action. That's the point. And England adopted, after the directive, a new statute amending its regulation of consumer rights, and it introduced a class action, an opt-out class action for antitrust damages. Therefore, going exactly in the opposite direction, notwithstanding the general trend and notwithstanding the directive, they said, no, for this specific kind, it's a kind of pilot. Let's see how class action, an opt-out class action can work for this kind of damages. Actually, for non-residents in the UK, the opt-in system exists, but this may have sense, maybe a possible, I mean, we are trying to find the European solution. This could be a European solution. A distinction between the residents and non-residents can have a sense. Let's just say, let's test it and see what's going to happen. Then also Italian class action had some interesting development concerning the Dieselgate cases. We don't have, I mean, all over the world, the Dieselgate produced damages to consumers. And what happened in Italy was the consumer association started class actions in two courts, one against Fiat and the other against Volkswagen, and with the opt-in system. But the number of people who applied to enter in this class action, as far as, I mean, these data are available on the website of the association. But, I mean, even if they may be a little bit inflated, they are significant. For the first case, the one against Fiat, it was more than 21,000 cases, people, and against Volkswagen, more than 90,000 people. And this means that when there is information, when people are aware that their right has been infringed and that there's a tool, I mean, this kind of class action, even an opt-in class action, may work. Just the last point on this. Also at the EU level, there's some promising signs, let's say this way. The new document just delivered in April by the new Juncker Commission, a new deal for consumers, stating policy aims, very general about consumer protection of consumer rights, but again, the idea of a kind of representative action for damages surfaces. And especially with reference to cross-border cases. The Dieselgate, again, is a situation that, I mean, could produce interesting results. Could. But, I mean, there are signs, positive signs. We can just wait and see what happens in the implementation of these things. Then the third wave, the access to justice approach. According to Capelletti, the third wave was, I mean, a full panoply of institutions, and I'm quoting, devices, personnel and procedures used to process and even prevent disputes in modern societies. So everything, institutional, procedural reforms. Now we tend to reduce access to justice, the third wave, to ADR, which in Capelletti's idea was not. And there are very interesting ways that could be promising, interesting reforms at institutional level, procedural level that could produce these results. But then I would like to concentrate on ADR because, I mean, the current day debates, these two ideas, the third wave and ADR, tends to be identified, really. And because it is interesting, and because the ADR movement reached Europe too. We have been dealing with this increased interest, at least, by legislators on ADR for several decades. And at the EU level, we have three main instruments. I would like to focus on briefly, of course. The first one, a directive adopted in 2008, concerning certain aspects of mediation in civil and commercial disputes. So a broad area, civil and commercial disputes. The directive only referred to cross-border disputes. Again, because in civil procedure they have limits. But it is considered probably the most successful instruments in this area, because almost, or at least the majority of states, when implementing the directive, extended the regulation also to domestic mediation. And so the final result of this directive is that at the EU level now we have a common framework, a common regulation, some basic guarantees and rules, and consider that the previous situation was no regulation, patchy regulation, uncertain regulation. So at the regulatory level, this has brought a significant result. Probably just a few words about the main features of this common regulation. Of course, confidentiality, of course, the needs to guarantee the quality of mediation, mediators, and all. These are very basic things. One thing I would like to stress, with this directive, it became possible to have court-annexed mediation in all systems. It was not so clear before. And it was possible to have compulsory mediation, provided that, and the European Court of Justice specified the limits, the procedure brings to a result which is not binding, because mediation has to remain voluntary. It does not bring too much delay. It is or costless or has just low cost for the parties. And it suspends the period of time barring. That's another important issue, and guarantees the possibility to have interim measures if the parties need it. Insofar as these conditions are fulfilled, we have a true access, a possibility to have true access to justice. And this directive was also useful because it raised awareness of mediation at all levels. A lot of mediation institutions, training in mediations, conferences, books, a lot of readings and academic interest. But if you look at the practice, at the effective results of mediation, available data says that on average, less than 1% of cases in the majority of EU states uses mediation, less than 1%. Another data is the successfulness of mediation. In those very few cases, mediation is highly successful. But the problem is not once you've entered mediation, you get to the result. But the problem is, it is a successful directive. Do think what would have been if the directive was unsuccessful. So that's the problem. And the problem. So the question: why? The answer is not the regulation. We have all the regulation we need. It's a problem of awareness, and it's a problem of cultural resistance, because we do think today access to justice equal access to a court and to a court decision, not simply to a court, but I do want my case to be decided by a judge. It's there for that reason, and that's a fair trial. Any other thing is second-class justice, second-rate justice. And that's what many people think, and that's what many operators think. Judges, because they are important. You want to keep away from them their importance, and lawyers. Here we have economic resistance. Their fear is losing a source of revenue. Let's be clear. They are the main source of information for the parties. If they just inform them about the existence of mediation and say, but it's not the thing for you, no mediation. I do believe in the usefulness of mediation in some cases, but the situation is not so good. And the other instrument concerns ADR for consumer. So just a group of cases, consumer law, but ADR in general, not just mediation. And again, a directive, 2013, more or less with the same features, non-binding, protection, all this. I mean, the substantive regulation is the same. What is clear is that there's a political will to promote a mediation. Legislators at the EU level and at national levels do promote mediation. They tell us that it is for access to justice. Well, one may wonder whether it is not to reduce the cost for the public purse. That's the problem. Because for many legislators, mediation and ADR in general are a tool to reduce the workload of courts. They just see mediation in this perspective. They don't see the positive side, I mean, a more appropriate way to solve some kind of disputes. And until they see it this way, I don't know how promising, how they can achieve this final aim of promoting mediation. So in the end, access to justice, the movement was connected with the welfare state. So the development of the welfare state brought within it the development of access to justice. The welfare state is in crisis. I mean, it's a fact. But access to justice is not. And the problem is how to cope with this crisis in funding and how to, to prevent these very important, very fundamental, probably I could say the most fundamental right to be just used as a kind of, let's say, brand to promote reforms, which really not always have to do with access to justice. Well, thank you.
Thank you, Professor Alessandra. I think that here we have this concern about because in Brazil we did not get the welfare state. We just jumped this part of history. But we always think about what is access to justice in this context, now where we have an economic crisis, and I'm starting to conclude that maybe access to justice is not a universal right, something that Capelletti used to proclaim. I think that maybe we have to understand that it is a right that has to be distributive. And we have to start to think about who are our priorities in distributing access to justice, because we don't have the structural and the money to give access to justice to everyone. What we see in Brazil is that the repeat players have access to justice, but not the one shooters using a Galanter framework. But I think that my colleagues are going to talk about this later. And I realized that I'm not being a good chair because I didn't introduce the previous speakers. So when you talked about FIrenze, I just realized that. So I would like to apologize and then say that Professor Rebecca Sandefur is from the University of Illinois, and that Professor Alessandra De Luca is coming from the University of FIrenze. So now who's going? I think Luciana, maybe, because can it be? Yeah. So I'll give the floor to Luciana Cunha, which is professor here in Brazil in the Direito GV, Fundação Getúlio Vargas, so that she can speak to us. Thank you.
Okay, good morning, everyone. It's a pleasure to be here. Thank you for the invitation to be part of this panel with old friends and new friends like Alessandra and Rebecca. I am listening for your, and also Adriano. I am listening for your speak, and I am. It made me remember of my master thesis from 20 years ago when I apply a survey with the poor people who were asking for a help or for a legal assistance at public defender here in Brazil, which at that time was part of the branch of lawyers who works to the states. And since then, I am studying access to justice and particularly using empirical research and survey as a way to discover and to learn how population access the courts and what was their experience with justice system. But I would like to, I think that the case of Brazil is a little bit different because since the democratization 30 years ago, the role of bar association, public attorney, and also public defenders and popular lawyers made a terrific work to deliver some kind of access to justice for the poor. I think that we have another population that are extremely a part of the system, who are the middle class and the lower middle class, who are not able to have the legal assistance and the legal aid. Thinking about that, I would like to say some words. It's a very briefly presentation of new thoughts and how we can thinking about access to justice, and what is the result of the definition of access to justice as access to courts and the possibility of having conflicts solved by formal and legal tools. I agree with Alessandra that here in Brazil we also have this kind of problem that we want a solution by the state, and only by the judge it is a good solution, whatever it is. So when I am, first of all, when I am talking about formal tools, I'm referring to those ones recognized by the state. And in the case of Brazil, we have a first challenge with this definition, which is the problem is that it assumes that in the Brazilian institutional design, the judiciary is the only arena recognized to solve a conflict. This means that solve a conflict outside the judiciary is not good, and that even if there are ways to solve in a conflict that do not require formal procedures, it is within the structure of the judiciary, such as small claim courts, and from early years, centros judiciários para solução de conflitos, or núcleos permanentes de métodos consensuais de solução de conflitos, which are part of the judiciary and working with the same methodology and the same way. Why this is a problem or an immediate challenge in the case of Brazil? On the one hand, because it imposes on the judiciary that comes every day showing itself a failed system as a public service provider, another task. On the other hand, it causes the increase of the legitimacy of the judiciary and its control over the possibility of conflict resolution, leaving little or leaving no room for the emergence of forms of different conflict resolution that are effective alternatives to the judiciary. This means that for a judiciary that already account for 1.4% of the country's GDP in public budget, with 18.858 judges and 28.5 million new caseloads in 2017, there is no possibility or no workload reduction scenario or the possibility of improving the jurisdiction provision for a medium-term future. If we add to this situation the greater polarization of the society and the politics, and of course the economic and social crisis that we are living nowadays, the number for the next year of caseloads will be even more frightening. These numbers, on the other hand, are incapable of indicating the absence of the Brazilian state in several regions of our country, which also ends up even more our income concentrations and levels of economic inequality. What I'm trying to say is that one of the paradoxes of studying access to justice as access to courts is that we are somehow stressing the whole of the judiciary as the main arena to solve conflicts. With a failed judiciary, is it possible to demand response that fulfill the possibility of solving conflicts, taking into account the patterns we incorporate into the Brazilian constitutional system to guarantee social and economic rights for the entire population? Further, pushing this dilemma moreover, how to require that the judicial system distinguished by the difficulty to access and understand by the lay population, extremely formal, institutionally encapsulated from the other state spheres and from the society, corporatist, and with administrative and budget autonomy to be capable of meeting the social demands, which in the case of Brazil are more diverse given our social and economic difference. Is it possible to have something different from the maintenance of the status quo as a response from this system? I don't think so. In this sense, I disagree that it's due to the precariousness of the welfare state, but rather as an institutional design and a judicial culture, like Alessandra stressed in her speech, that places the justice system at the center of Brazilian social relations, with unequal access and different responses because of the lack of the public sphere to share a common vocabulary or a common language from which one can discuss their own preferences. Just to finish my purpose in presenting this provocation is to try to instigate the imagination and the creativity so that we can project a different society from what we have been promoted in terms of the right of access to justice. That's it. Thank you.
So now I'm giving the floor to Professor Carlos Alberto Salles from University of São Paulo.
Well, Good morning, everybody. I want to thank the ABraSD for the invitation, and also I want to greet my colleagues of panel, Professor Adriano, Professor Luciana, Daniela, Alessandra, Susana, and Paulo Eduardo, and Rebecca Sandefur. But I also want to congratulate our lecturers, Professor Alessandra and Professor Rebecca, for the very insightful expositions that I think that give us a great opportunity to discuss this subject in Brazil. I think I can say that we had more or less, I would say, an agreement between the panelists that we will hear our lecturers and we will make some questions for all the panel as a way to improve the debate this morning here. And I would like to really just highlight 2 or 3 points of the expositions. And the first, I want to highlight what I can call the iceberg problem that Professor Rebecca said, that a lot of problems the common people are not understood as legal problems. And my point is that if sometimes it's not the opposite. Mainly in Brazil, you have a lot of lawyers, a great supply of lawyers, and the legal service being offered for the population. And nowadays, I think that the question is not if every issue is not getting a legal issue. Sometimes very personal and important problems are made by transformed in suits in judiciary, and I don't know. Sometimes I think it's a little bit too much of access, and I think that I wonder if the society have to have its ways to solve these disputes without judiciary. I think that you sometimes you think that you have to bring everything to the judiciary, and sometimes, for example, you have a lot of cases where is everyday situations that is transformed in opportunities to recover damages. For example, to solve interpersonal relations, to solve arguments and between peoples, and this is my first question. If this iceberg is not really an iceberg, that must be kept as an iceberg with some more usual problems being solved by society for itself. This is my first point. I would like also make an highlight in a position. I think it's the Professor Rebecca's position. I got it in the PowerPoint, but not exactly in your speech, Professor, but also very important. That the problem of access to justice is that it is restricted. Only some situations are solved lawfully, others not. And the access to justice is unequal. Some groups and societies are more likely to get access than the others. And also about this, I think that should it be different, you really have to have a goal of the universal access to justice, or some situations are not better solved out of judiciary. Some questions, like, for example, political questions or administrative issues, or even some very personal family rights, for example, maybe it's better out of the judiciary. Maybe access to justice must be seen as somewhat restricted. Unequal. Unequal, I think that really the access must be equal. But what I think is today is really a problem of access, or is a problem of the internal features of our procedure systems. The inequality nowadays, I think, is not exactly a problem of access, but a problem as the procedural systems take care of the rights of the people inside the system. I know that it is the perspective of the view of a civil procedure professor, but I think you can go further in to try to identify really which are the problems inside of systems that made it unequal, where in matter of principle the access is possible. No, I have some other questions that you keep it for another moment. Okay, thank you very much.
Thank you, Professor Salles. I will let Professor Paulo Eduardo speak here because it's close to the microphone. Then we put that. So he's going to complicate my life so we can have a gender balance. Professor Daniela Gabbay from Direito.
Thank you, Susana. Good morning. It's a great pleasure to be here participating in the conference with my great colleagues and friends, and to hear Professors Rebecca and Alessandra. I had written some papers to the Law and Society annual meetings with Susana, Paulo Eduardo, and Cecilia, who unfortunately is not here, taking advantage of these meetings to write down some ideas about access to justice. I have also done some empirical research with Luciana at FGV about access to justice, so I bring some of our thoughts here. And we are looking to the access to justice not because it's a trend topic in Brazil, unfortunately. Actually, it's right the opposite, I think. It has been considered an overcome topic, or sometimes a non-issue topic. So everybody agrees about its importance, but mostly in the principle and theoretical spheres as a social right. And our effort is trying to re-signify the agenda of access to justice in Brazil, considering some premises. The first premise, and Susana talked about, is that access to justice is a limited resource, which is unequally distributed. So the universalization of access to justice for us is utopic. the access to justice needs to be implemented in a very different social, political, and economic context than that one of the Florence Project. So the universal movement of access to justice is not possible in our context. Having the premise that the blanket is short and access for all is an unfeasible goal. We have a lot of problem of naming, and I agree with Professor Rebecca. People don't understand the problem as legal, so we are trying to have some research. Luciana has a great research about who is going to the courthouse, for what kind of problems, how is the confidence in the courthouse. We also have a lot of expectation about the second wave, talking about the class actions, but we're talking about the limits of class actions to promote more access to justice. The second premise is that even having more than 100 million of lawsuits in the Brazilian judiciary, it's important to resist the discourse of a litigation explosion, since we have a lot of repeat players, including the state and federal government. I think that mediation, and Professor Alessandra talked about that, can be a non-lawyer word, considering Rebecca's speech, but I also agree that community mediation is totally different from mandatory mediation within the courthouse, more used to reduce the workload. So I totally agree with Luciana, that's the third premise, that to discuss the redistributive policy choices on access to justice, it's important to discuss the role of the courts. As an institutional issue, so the design of institutions and choices, we have some empirical research about that, but it's still very important to show not just system problems, but who is going to the courthouse in Brazil. Of course, I'm talking about my place of speech. I'm a professor of civil procedure. And we are facing this challenge to rethink the role of civil procedure in building the agenda of access to justice, bringing new challenges through legal education, research, and legal practice. I think that the contribution of civil procedure scholars to access to justice agenda, it's important, but means also a resistance in a very traditional and dogmatic field in Brazil. We have analyzed in our papers the political choices concerning access to justice in Brazil in the search of a new agenda, considering 4 legal frameworks. So the 1984 Small Claim Courts Act, in the 1985 Class Action Act, the Constitutional Amendment number 45 on judicial reform from 2004, and the new Code of Civil Procedure from 2015. And the hypothesis we have taken is that the redistribution of access to justice was no longer present in the political choices made in Brazil since the 90s, in view of the new liberal wave that marked the judicial reform agenda. So considering that these political choices greatly impact the relationship and imbalance of powers between repeat players and one-shooters in the litigation game. And we have analyzed the winning and defeated normative discourses behind the legal framework related to access to justice. So our hypothesis, once again, is that these reforms have gradually transformed the access to justice as a redistributive guideline of social rights into a non-issue. It's a kind of invisible. So we are now, in my perspective, in this moment, trying to reconnect the legal debate to empirical research, moving away from an empty discourse towards a consistent and plural reflection on the limits and potentials of courts and of granting access to justice to those who are excluded from the judicial system. So because of that, Professor Rebecca's papers are so useful for us, and I hope to read more papers from Professor Alessandra and try to connect with all of you to continue to research this subject. Thank you.
So now Professor Paulo Eduardo Silva from University of São Paulo.
Okay, thank you. Well, it's very nice to be here with you all. My colleagues, my friends, Rebecca, Alessandra, and all of you. Well, I guess I have two main points. And a lot of thoughts as well, but I tried to do two main points based on previous papers from Professor Alessandra and Professor Rebecca. And both 2 points are connected to maybe to one argument, which is, maybe we have been dealing with access to justice here down in Brazil for the last 30 years based on just an exclusively institutional perspective. Kind of, we did our homework, we surfed the three waves, we developed an institutional set. And after 30 years, we said, oh, so we did the homework, but we don't have access to justice, so access to justice is not important anymore, or is not the same thing that Capelletti said, is a kind of efficiency-oriented access to justice, which in my point of view is not access to justice anymore. I have the same sense that it's just a label or a brand to promote for legal reform, so which is a different kind of. I guess my argument is that maybe we should try to understand access to justice based from the bottom up, Rebecca, I guess, from a constitutive perspective, thinking about access based on what do people need instead of what do courts need. I totally agree that courts has a lot of work, but actually it's our problem too, but it's courts' problems too. Once it's courts' problems, it's our society's problems too, but well, we have other problems too. And I'm going to organize this paper, this argument based on, well, some data. Susana mentioned some numbers here, but well, to our foreign colleagues, almost 200 million lawsuits. Oh, sorry, almost 200 million inhabitants, around 100 million lawsuits. We are around almost 1 million lawyers and more than 1,000 of law schools as well. So maybe lawyers, we have an army of lawyers that could be used to provide access to justice, not just through courts. And well, and I guess all of them are capable of having those kind of procedural expertise or relational expertise, which are so important based on Rebecca's paper. Another data. Small claims courts research on small claims courts, civil courts in 2015 in it's not a national wide, but it's 5 capitals of the country, revealed that parties, individuals, they do prefer to have lawyers with them. It's not the first research, there's not the first work that revealed that, but it's another work that confirms that people prefer to have a lawyer with them, mainly in lawsuits that they litigate against a company, someone who's stronger than them. So it's not as simple as simplifying proceedings or trying to leave the lawyer outside. I guess people prefer, and this is our profile of lawsuits. We have individuals against repeat players. So, well, and when we have lawyers, we have pleadings of higher amounts, or actually longer petitions. I'm not sure if this is good or bad, but more appeals and less settlements. Well, I'm not saying that it's good or bad. And some other analysis based on access to justice, the same argument that we did the homework, but we did it on an institutional basis. Well, somebody has already said that we just read the general report of Capelletti and Garth, 4 volumes of work, and mainly, I guess we dealt with it just as a book recipe instead of thinking about what were those premises. And I do believe that they have inequality as a basic premise. Capelletti was thinking about access to justice, but he was thinking about providing us an institutional set to reduce inequality in society. This was his main goal, and Garth's as well. And after Capelletti and Garth, we didn't, mainly, when I say we, I say civil procedures, maybe sociological professors. They probably had contact with those papers, but I guess we didn't get too much contact, for instance, with repeat players idea from Galanters. It's 5 years old argument with us. I guess Carlos Salles is one of the first who brought us Galanters arguments. We did have no contact with dispute pyramid rather than Daniela's perspective and Luciana in a 5 years old paper. But we didn't have any contact with legal mobilization, naming, blaming, shadow justice, just few a lot of lawsuits, a lot of debate, a lot of works, a lot of data developed to understand how people address their own problems. We did have no contact with that. When I say we legal civil procedure professors, legal professors. So based on that, once we don't have the whole perspective to understand access to justice and a lot of analysis, we had just one way out, which was, no, we don't want access to justice anymore, or access to justice is not anymore inequality, is a kind of efficiency-based. We have to deal with a lot of lawsuits on courts and provide more efficiency, and well, which is not, maybe we are throwing the baby away with the water, with the bath water. And I guess we could illustrate this last argument based on our recent new code of civil procedure. Once we have, in 1980s, an institutional perspective on access to justice, we had in 2010 an efficiency-oriented perspective of access to justice. Access to justice quoted, because I don't believe it's access to justice. In fact, we have current legal reforms that are focused on judicial management, arbitration, judicial mediation, almost mandatory mediation, as Daniela said, flexible proceedings, and a typical model of precedent system. I have serious thoughts that those kind of reforms, if they would provide access to repeat players again, or they would provide access to people who are apart from the system trying to get in. Maybe those policies are much more concerned on reducing dockets instead of providing access to justice at all. Which scenario we could have? Maybe next paths to access to justice in Brazil, just to summarize and to finish it. Maybe give some attention to works that try to do the same thing that Rebecca did, which is what are the popular demands for justice? Thinking from the bottom up view, thinking or considering that it is an access to justice retrenchment, which I would say that could explain the class action retrenchment, and even a kind of thinking on ADR as just some kind of possibility. And I'm going to finish with an example. I have an advisor who is just delivering his work. He's a defensor público, public. It's a defensor público. It's a kind of public attorney in Brazil, and he's trying to understand why Defensoria Pública in Brazil, despite the fact it was the Defensoria Pública in São Paulo state, despite the fact that it was created based on a social movement pressure and with a lot of, I could say, access to justice ideas, suddenly or in a slow pace, it turns into another kind of same way of doing legal things amongst judicial system. I could say that even if we create a new institution trying to provide access to justice, I guess the culture or the behavior or the perception of something which is not directly related to some institutional set provokes some chance and retrench those guys into a traditional position, as I could say like that. So maybe the problem is not on the first thing we are saying, a lot of lawsuits and a lot of, maybe we could try to understand from the bottom up and trying to understand how things got into this poor perspective of access to justice that we are dealing with nowadays. Thank you.
Good morning, everyone. Nice to meet you. I'm Caldeira, professor of civil procedure law at Mackenzie University. It's a great honor for me to participate in this debate related to topic access to justice, especially together with such important researchers. I also like to thank my dear colleagues, Alberto Salles, Professor Susana Henriques da Costa, Paulo Eduardo Alves da Silva, Professor Luciana and Daniela Gabbay. So, I'd like some quick notes about access to justice in Brazil. The research about the access to justice requires us to consider some questions. For example, what exactly do you mean when you talk about access to justice? Where's the role of the lawyer, the judge, the minister of public ministry, in improving access to justice? Are the issues regarding access to justice of an ideological, economic, or legal nature? It's possible to define it. So, the debate on access to justice has received a lot of attention the last 20 or 30 years. However, that does not mean that we are moving towards a more humane justice. Especially then, the procedural law in which the debate is reduced to the single idea of access only to judiciary power. Traditionally, when we study the fundamental rights and guarantees, we do it from the idea that judiciary power is the most adequate route for the effectiveness. Precisely for this reason, we tend to think of access to justice as a guarantee for a process developed without delay, impartially judged, present with the contradictory, complete defense, and so on. Nonetheless, one cannot lose sight of the fact that today's model of a process is the same of the unction regime over the technical, privatist, and elitist. It's essential to remember that, first, the judiciary as an inseparable part of the state is a result of the social and political form of an era. Second, the state was not designed for the protection of social rights. Therefore, it doesn't know what to do. As Vittorio Denti and Michele Taruffi note, this model for procedural thinking started from the mistaken premise of a social constituted by equals. According to this premise, if a party is defended by a lawyer, for example, that should be enough, regardless of the professional's knowledge, and the proceeding cost are not taken into account. So, when speaking of access to justice, we must abandon the limits of positivist culture based on equality that does not exist in the reality of life. We must leave the palace of justice and look at the reality of the street. It's not reasonable to discuss access to justice without considering the 2,000 street dwellers in São Paulo alone, or without considering the fact that Brazil is in one of the most racist countries in the world. There is only the access to justice when it's thought from the reality of life. Some information about access to justice and the judicial legal in Brazil. I think that is important. In Brazil, legal aid is provided by an insufficient number of public defenders. For example, recent researchers has revealed that in Brazil there is a deficit of about 10,000 public defenders. And what's worse, exactly in the areas where there are more poor people, the number of public defenders is smaller, which highlighted the absence of public policies about access to justice for poor people. Or the legal aid in councils can also be provided by private lawyers, but the fees are very low, which discourage lawyers from acting in the system. Another problem is that until recently, pro bono legal service was forbidden in Brazil. There isn't a culture about pro bono legal service. There is a sum of the situation that reduce the effectiveness of legal aid in Brazil. So, anyways, we still have a lot to talk about when it comes to access to justice. I believe that this meeting be just the beginning of the network of researchers concerned with justice from all for all. That's it. Thank you.
I'm going to be brief because Professor Paulo Eduardo wants the public to talk, and we are shortly on time. I would like to dialogue with Alessandra and the second wave that issue that you put on discussion here, because I think that the Brazilian class action is always commented from Europeans, because we are a civil law country, and we were able to talk with the common law experience and develop our own class action. But in inner, I think that what is the difference between Brazil and the European countries in this wave discussion, it's not a problem specifically of having a class action instrument, but I think it's interior problem. It's that our separation of powers, as our institutions are dimensioned differently, because we do give the judiciary the power to decide about political issues. And that's something that, I don't know, but in my impression, is completely different from most of European countries, because the discussion about political issues are given to the political powers, the legislative and the executive. And we did a different option in our institutional arrangement. We do believed that the judiciary was a good arena for this kind of discussion, and that led us to the class action law and other instruments that did made it possible. I think we had, first of all, made a different choice, and I would like to hear from you after that. I don't think it's simply a kind of resistance from the market. I think that it's a problem, but I think it's more institutional design, a different arrangement. But as you said, yes, in Brazil we do have a class action, and our judiciary do decide about public policy and everyday basis. And I like to study a lot about class action in Brazil, and I think the consensus now is that this intervention it's very inefficient. We do not have a success experience, I believe, because inefficient in what way? I think we were not able to design a model where the structural reform that Owen Fees talk about. I don't know if you know his paper, but this kind of his structure reform that change the structure of a bureaucracy, a state bureaucracy, it's possible. I don't think we achieved that goal. And I think that our class actions, sometimes when they are efficient, they are limited to small changes and something, and the judicial decisions, they are efficient when they are pronounced in a very traditional basis, a kind of indemnization decisions, the status quo maintenance decision, to put the status quo to again in order, not to promote a social change, this kind of objective, the dream, because when you talk about class action, you are believing at the potential of the judiciary in doing social transformation, and I don't think we were efficient in that experience. And now, also in Brazil, when we discussed in the 80s the adoption of the class action model from the United States, what was debated was the possibility for the class actions to deal with this mass litigation, because we were going to have one big issue, a mass conflict, deciding in one lawsuit, and that would prevent for us to having millions and millions of lawsuits, individual lawsuits, caseloads, dealing with the same question. But that was not a reality, because a political choice was made, and that political choice was to not forbid individual claims when you have a class action, so they can be fused together. And we did not, there was not a conclusion that for a social perception that the class action was going to be efficient, so that I don't have to file my lawsuit. On the opposite, here in Brazil, most of individuals want to file a lawsuit when they decide to do that, because they understand that the class actions are pretty inefficient. They are going to last longer than the individual lawsuits, so you don't have advantage in waiting for the decision of the class action. And the reaction, the institutional and mostly the normative reactions that the Professor Paulo Eduardo talked about, and Daniela also, to design a procedure change in our Civil Procedure Code of 2015, which can be called the sample trial, which is to something like I don't know how to speak well, but I think the Musterverfahren from German experience, which is this idea of selecting some individual caseloads to decide a question, and then using the idea of precedent from the United States to make this decision binding. You know, and you have a lot of problems in this technique. They don't talk about adextral representation, but I don't want to talk about that now. What I want to talk about is that because class actions in Brazil were not so efficient to deal with mass litigation, we had the judiciary as an institution, because these lawsuits were, this new civil procedure code was, has as his, how do I say, his father, a ministry from our Supreme Court. It was almost, it was mainly a judiciary project, you know. We see the judiciary as institution have to react to this mass caseload situation, this mass situation, and then he developed techniques that, if our class action did work well, would not be necessary. So we have here in Brazil something that I think it's different from our other countries, because why Germany has the Musterverfahren? Because Germany doesn't have a class action instrument. Germany has a different understand of separation of powers. So they have to deal with some massive situation, a lot of caseloads, and they have to develop a case management procedure. But in Brazil, we do have class actions. Yeah, so why do we need that? And this is the new trend. This is being it's German, but everybody is talking about that as the Dag of Colombo. I don't know if this is a kind of translation. Yeah. Something that's going to solve our problems. Yeah, I don't believe in that. I think it's a completely wrong way to deal with the problem. And nobody... in another way, I see Carolina here. We were we argued here at work last week, and she was talking about another trend in Brazil, which is to import now the literature from the United States from the 60s about structural reform, and to start to question about the potential of the judiciary to deal with the structural problems, but in a very particular way, which is a very dogmatical point of view in Brazil. We are asking what do we have to change in our civil procedure rules so that we can make our civil procedure able to deal with that. I don't think people are asking the main questions here, which are, do the judiciary has the institutional capability to do that? What are the limits? Can the judiciary do redistributive transformation? And do class action really empowers the one shooter in Brazil? Those questions are not being asked, and I think that we have to. We are trying to put that agenda in debate. So I'd like to say that so that we can talk about and discuss the second wave too. And thank you. Now the public, the audience. Please, can you come here and talk in the microphone so that Professor Rebecca can hear you? You can introduce yourself.
I'm Nuria Lopez. I'm PhD from Legal Philosophy in the Pontifical University. First of all, I would like to thank you, all the professors, for the lecture and comments. It was really nice. And I would like to make a question about Professor Sandefur's start point. That was a great one. She said that ordinary people don't experience just problems as legal problems, but as life problems. And I think that's really important because we can think about institutional design. There are for people. And also, in the other hand, the response they get from institutions will inform them this experience. So I would like to ask Professor Sandefur why people experience things, their problems like that, as life problems and not as legal problems. And I would like to ask also Professors Daniela and Luciana from their research, empirical research point of view, if Brazilians do the same and why. Thank you very much, professors.
So, please, Professor Rebecca, did you hear? Oh, I'm sorry. I don't. We are not hearing you. Wait a minute, please.
How about now?
Yeah. Now we do hear.
All right. That was a fantastic question. Thank you very much. I think the main reason that people don't experience their problems that have legal aspects as legal is because of the way these problems emerge in our lives. So if my problem is that my employer's not paying me a fair wage, that it's true that violates laws, but I experience it as this person is a jerk, as we would say in the United States. This is a bad person who doesn't behave the way he should. The other thing that happens is that because these problems usually emerge in relationships with maybe people who we know, I think an interesting question would be, are we more likely to see the legal aspects of problems that emerge with bigger institutions where we don't know someone? So a government bureaucracy or a huge bank where I have a credit card? I don't think we have a good answer to that. But the problems that emerge in relationships with people who we know, we want to preserve those relationships in a range of ways. So a few years ago, I did some focus groups with low-income folks in different parts of the country. And one of the things they talked about was the bad conditions in low-income housing. So you don't have heat in the wintertime, or you don't have hot water, or you have lots of rats or cockroaches or something. And we would ask them, well, why didn't you do anything about the fact that you had no hot water, or that it was very cold in Chicago and you had no heat? And they would say, well, last year when I couldn't pay my rent for 3 months, my landlord was really nice and he let me work out a payment plan and he didn't file a lawsuit to evict me. So I'm going to be nice to him. I feel grateful for this. So because particularly for things that emerge in personal relationships, that relationship colors the way you think about the problem. I think where we would have more scope to sort of try to understand how a public education campaign could help somebody think about their problem differently would be problems that emerge between an individual and a big impersonal organization, whether it's a government or a private company. I think there's more scope there to sort of shift people's thinking about a consumer problem with Citibank rather than a consumer problem with your neighborhood dry cleaner or something like that.
Thank you for your question. I think that in Brazil, it's the same about this continued relationship and lack of information. From the research perspective, maybe Luciana can tell more about this research about the confidence of users, from the users of the court system. But I think that sometimes it's important to give some examples of conflicts so they can hear the conflicts and see if they have the same situation in their lives. I think that there are some methodological choices to be made about that, because this path, like from naming to blaming and claiming, like from the bottom to the top, as Paulo said, is so difficult to go through this path. So from this methodological research perspective, sometimes you need to give some examples of situations and then hear from the users how they can deal with that, from the labor, consumer, family problems. But maybe Luciana can tell more about that.
Thank you for the question, Núria. I think that in the case of Brazil, we have different perception about legal conflicts or real conflict as legal conflict. The main difference is from work, labor justice, and civil justice. We have to see what it will be different since we had this very recently reform on labor law. But from my, especially from Confidence on Justice Index, what we saw is that on every kind of relationship beyond the labor relationship goes to justice, because of we will have free or some kind of no costs to go to the judiciary, and all of our work relationship are very regulated. So and people know about it. The problem is with the population that are not in the formal market of work. So in this point of view, we could have some difference. But the main problem is the experience in this judiciary, I think, and how they are not feel as part of this kind of citizenship. So it's not just to relate their own problem as a legal conflict, but that this kind of state provision is not for them. It's for the elite and for who has a contact with, who know a lawyer who can pay for the lawyer service. Okay.
Well, we are on time. We have to finish our panel. I would like to thank you for everyone, every speaker, and to thank you for the audience too, for being persistent and staying here for this morning. Thank you very much, Professor Rebecca. Thank you very much, Professor Alessandra, for coming from so far to talk to us.